What?
The mayor or the sheriff of San Francisco is defending his
What?
His
What is this?
sanctuary city policies.
Should we go?
We
should
need to go to
listen.
this. We were told he was going to speak yesterday.
Oh man.
This is the sheriff of San Francisco. A lot of people criticizing him.
Comply and would have complied if that legal order or warrant would have been presented to us. In Gallara, U.S. Court of Appeals, Third Circuit, March 2014, and Miranda Oliveras versus Clackamas County, U.S. District Court, April 2014, affirms exactly why San Francisco Sheriff's Department and over 300 other cities that have since changed their laws that stipulate how municipal jurisdictions are to interface with ICE is exactly the law that we adhere to and that we follow. On February 12, 2015, in this very office, we are sitting and where you are standing. I met with Homeland Security Deputy Director Mayorkas, along with our undersheriff and along with our legal counsel, Freya Horn, and another member of our staff who isn't here today. I informed Department of Homeland Security, Mayorkas, who presides over the question and of the operation of ICE, that a warrant or judicial order is required to detain someone for pickup by ICE authorities. ICE has known this well over a year since the Board of Supervisors in San Francisco passed the Due Process for All Ordinance in October 2013, which was signed by then Mayor Lee. And that the City and County of San Francisco and that the San Francisco Sheriff's Department policy require a warrant or judicial order to detain an individual in custody for transfer or delivery to ICE. So over a year had transpired, direct communication with the top leadership of the Department of Homeland Security here in San Francisco, here in our office and elsewhere, affirmed the city's position. And many other cities, mind you, at this time, have already changed their laws. So this is just not unique to San Francisco. Federal authorities did not proceed directly with deportation proceedings as they had done previously without clearing the San Francisco felony warrant. We have obtained a Homeland Security memorandum, which I imagine you all have seen too, dated November 20th, 2014, set forth civil immigration priorities for deportation. Mr. Lopez Sanchez met ICE's highest priority due to previous felony convictions and prior deportations. However, as I contend, and I will continue to do so, ICE failed to obtain and provide a warrant or judicial order for such deportation proceedings. Why would they have completely ignored the 20-year-old bench warrant for marijuana possession and sales previously and then had deported him, and then this time they decide that this warrant required a detour from their normal procedure. Recommendations. And this is important because what we're seeing everywhere is a lot of finger pointing. And what we're seeing is a lot of distortion of facts. And what we're not hearing, I think, is the summoning of the collective wisdom to help us understand and improve upon the inherent conflicts between local, state, and federal law and the deficiencies that continue to propel this tension. On potential considerations, on considerations for recommendations, warrant process. Resolve the conflict of ICE compliance, local law, and the Fourth Amendment violations by exploring the use of an administrative law judge for judicial oversight. Something that is not just unique to San Francisco City and County, but other counties is we do not purge our felony warrants. In the county of San Francisco, felony bench warrants are there in perpetuity. As of July 1st, 2015, there are 12,440 warrants. Other counties actually have a process for purging their warrants. Now, there may be very good cause, and I agree that there is, to not purge felony warrants. However, when you reflect on this particular matter, an administrative law judge would be able to help render a decision about the necessity of the need in their imperative to bring back Mr. Lopez Sanchez on a 20-year-old warrant that wasn't going to be prosecuted anyway for a failure to appear. That would require any reformation of that process for all criminal justice partners municipally to establish a review board for possibly purging felony warrants and determine how that interfaces with state and federal agencies. To do so that we can move forward, our agency requires indemnification and institutional support. And that means that we, as we have before and continue to do so, adhere to local, state, and federal laws. If there are conflicts in the law, we request the law on the federal side as it relates to the local law, in this case, the Due Process for All ordinance, passed by the Board of Supervisors, signed by Mayor Lee. If they would like us to deviate from that law, whether the spirit or the letter of the law, then as a former member of the Board of Supervisors, we require legislative direction so that then it is our deputies who are not overstepping their jurisdiction and acting like administrative law judges themselves to determine which warrant to follow and which warrant to not follow. Now, I want to end with this recommendation. With this observation and fact. I met with Homeland Security Secretary Johnson on April 20th, 2015 in Oakland, Alameda County, with other sheriffs from the Bay Area and region. Secretary Johnson requested that input from various sheriffs to comply with local law and for recommendations on the prospective priority enforcement program. There has been a suggestion by the feds that there is a new program for ICE called PEP, and that was, I think, inferred in the November 2014 memo. However, both in our meetings here in February 2015 with Deputy Director Mayorkas and in April with the Cabinet Secretary for Homeland Security that governs ICE, they all spoke that this is a prospective program that is not into effect yet. Naturally, they were eliciting our input as the Bay Area and regional county sheriffs. Mind you, many of this time have already changed their local laws. 50 counties out of 58 in California, to be exact, have laws similar to San Francisco to see how we would be able to acclimate to this new priority enforcement program. I made it very clear in that meeting to the Cabinet Secretary, in front of everybody else, that while that all may sound good and fine, we are still required by local law to reconcile the conflict of any kind of violation to the Fourth Amendment, as it had been deemed by U.S. District Court and by the U.S. Court of Appeals, 3rd District, and the ordinance Due Process for All. I recommended to the Secretary, in front of a crowded room of sheriffs and his top staff and other officials, that he and his staff come to San Francisco and that they work with our local government or to have a town hall in San Francisco to suggest where they want to go, with this idea, considering just how high profile and prominent the issue of immigration, sanctuary city laws, and most recently the Due Process for Law is. That's where the conversation had ended. It is extremely sad that we are here in this place reflecting on the killing of Ms. Steinle and looking at how we can prevent further tragedies. And this brings me back to my days when I was the District 5 supervisor, which encompassed Western Addition, Haight-Ashbury, other neighborhoods, where I made it a point, because public safety was important to me in my time as a legislator, to attend every homicide scene, which I did in the 7 years when a murder had occurred, and then meet with the family or loved ones to sort through and assess ways that we can prevent tragedies from happening like that again. I haven't left that same instinct that I carry forward as sheriff, so that to the family, when they're ready, and if they should care to, I would be more than happy to meet with them again so that we can learn from this and summon that collective wisdom without the political opportunism to remedy what has been spotlighted by this incident. And I hope that the legacy of this tragic event propels all of us, I think, to muster the measured minds at how we can improve public safety without eroding constitutional rights. I'm going to end here in the formal. I'd like to take some questions, and I'll do the best to answer as I can.
Yeah, Sheriff, you cite state law, you've also cited federal ICE law. The state law says that a law enforcement official shall have the discretion to cooperate with immigration officials in the instance of a convicted felon. You had one of those. Was discretion not used? Why wasn't state law looked at? And is this not just a simple lack of judgment?
Well, not at all, because our due process for all ordinance comports with state law, and it's clear that in the due process for all ordinance passed by the Board of Supervisors and signed by the mayor, asks us to respect and require that a judicial warrant or court order be obtained, and we've been consistent in that matter.
Sheriff, the mayor says that there was nothing in that ordinance that would have prevented you from picking up the phone and notifying ICE of the release. And to follow that, once there is an outstanding warrant, do you have any wiggle room to refuse it? Those two questions.
Well, that's
you have said, no, you guys keep them, we don't want them. And is the mayor wrong by saying that there's nothing in the ordinance preventing you from picking up the phone?
The mayor's throwing his own law under the bus, simply trying to walk away or run away from the very ordinance he signed into effect. Because if in fact that he's looking for some ambiguity in the law in order to cover his position, then it really defeats the whole purpose of the law in the first place. If you look very clearly in the declarative sense of the law of what the intention is, if you follow, his theory or logic, then they're asking us to use a subjective barometer that would then eventually conflict with the constitutional concerns that motivated the birth of the law in the first place. I really do think that the mayor is playing politics with public safety, and I really think it's disingenuous the way that he's been going about this.
And the second question?
Go ahead.
You said that your deputies reached out to ICE on their own because they felt it was the right thing to do. Are you saying that using their discretion to communicate with ICE absolutely has to be abandoned because one side needs to fit all?
I think you're kind of conflating. What happened when due process for all and the U.S. federal district court and then the U.S. Court of Appeals rendered their decision, thank you, rendered their decision, the idea for our deputies is they needed specific instruction. And where the instruction lacked in the local ordinance, we helped then augment that by explaining that if you have any questions whatsoever, contact our in-house legal counsel. But the subjectivity of a deputy, an aligned deputy, to say in the middle of the night decide who gets called in ICE and who does not is a liability that shouldn't be deflected onto any peace officer. SFPD and peace officers can't sign their own search warrants. The detainers decided to not be a legal document for a deputy on their own whim to decide that a phone call must be made so that that would help propel the facilitation or transfer of somebody without realizing the constitutional liability that already been applied is at risk.
Hey, Sheriff, at a certain point, shouldn't common sense rule the day that you see somebody who's got multiple felonies, has been deported numerous times, at a certain point, absent of the law, is there a common sense element that it's probably just not a good idea to release this guy back into the wild, if you were? The second point is, were you personally aware of the Sanchez case when it was happening in real time, or did these things happen just in the background where you were not aware?
In the background, because this would be the normal procedure, where we wouldn't be aware of his entire rap sheet. But with regard to common sense, the common sense move is exactly what we've been stating from onset, that ICE should have deported him. They didn't need to bring him back. And no, despite recent reports in the press, we didn't seek him out. A bench warrant is different from a district attorney warrant. We can intervene to the SF district attorney on a bench warrant. We cannot. That's the magistrate.
If you had to go back in time, in hindsight,
So that means
if you
you
knew,
can't
Sheriff, if you
refuse
knew
him?
that you had somebody
That's
in
right.
custody, knowing what you know now, if you knew that you had somebody in custody who had been deported 5 times, had 7 felonies, would you have done the same thing? Or, knowing what you know now, would you have picked up the phone and called ICE and said, this guy is being released?
One step even better, I would actually go down to their office on Sansom Street and say, do your job. Because we've been telling him that for 18 months leading up to this very event. Do your job.
So why didn't you call then if you said do your job?
Well, because we were actually following through in the course of our protocol as prescribed by local law. Get a warrant, get a judicial order. We're being consistent, and we have notified.
So many prior convictions that as a sheriff who's supposed to protect the public, that you would just let this guy loose without any proper following up, that you don't, picking up the phone is so easy that nobody in the department did that.
Well, it's not true. What is true is that they were well notified, ICE, as well as the Bureau of Prisons, in the beginning, that we require a warrant or judicial order. The felonies that you're speaking to are nonviolent, and it doesn't even meet the threshold of the local law that would require us to pick up the phone or use our discretion. So the subjectivity of deciding that Mr. Lopez Sanchez meets a certain threshold, I would disagree. The first threshold that should have never even got this far is ICE themselves. If ICE had deported this person 4 times in the duration of when this 20-year-old warrant had been active, but never honored the warrant to begin with during that 20-year period, I don't think you should lose focus on that question.
Can you speak to how often ICE doesn't follow warrants in San Francisco because they might fear that if you fall into sanctuary city, do they do this normally, not honor warrants in San Francisco? Do you know of this?
I do, yes, and their common practice is they do not provide warrants or court orders. I can't, you would have to ask them as to why, but I've heard that's been reported is that it is just inconvenient. That's what I've been reading in the paper, that they don't have the staff or the resources to pursue a court order or a warrant. If that's true, then it's inconvenient for us to be testing the erosion of the Constitution. And that's part of the inherent conflict that needs to be reconciled and has been well I think well explained to the leadership of ICE.
Ross, why don't you just say, no, we're not going to take it? Why do you have to go pick them up?
Because a bench warrant, yes, we are. We're obligated. On a bench warrant, not a San Francisco District Attorney warrant, we have to arrange transportation once we get that call. And again, let me preface, the call was initiated by the feds. We did not initiate the call. We did not seek them out. We are obligated as a law enforcement agency and as the Sheriff's Department, when a bench warrant is called in, We're not prosecuting, we're not judging the bench warrant. We're simply following through on the protocols. If we want to change those protocols, as I mentioned or referenced earlier, I'm recommending how we may be able to do that.
How many ICE detainers would you say you received in the last year, and did you honor any of them?
There's been 0 detainers that were honored in the first 6 months of 2015.
How many did you get?
I couldn't tell you how many we got.
Sure. 100, 1,000?
I couldn't tell you.
Sheriff, is there anything that you or your department could have or should have done that would have prevented the death of Case Sanchez?
It's a good question, because I believe that we had made very clear to ICE and to the feds, both through local law and through communication of this department, direct to the leadership of ICE, what we require. Could we be more emboldened or loud about that? Perhaps, but if we're being asked to undercut, subvert, or cheat the law that we're supposed to adhere to, then that really becomes a real conflict that I think we need to have, you know, a more larger discussion, a more collective decision.
Sheriff,
yeah.
I believe you said that you held Sanchez for 2 weeks.
2.5 weeks.
2.5 weeks after charges were dropped by the district attorney's office. What legal basis did you have for holding anyone for 2.5 weeks without charges? Aren't you violating his rights?
We are. We potentially are. The reason that we had held him for 2.5 weeks beyond his release date was to reconcile what was not clear in the federal paperwork had he completed his time for federal sentencing. And once that was determined, because of, on their end, confusion about what his expiration date was, then we finally released him.
But we held him. Was done.
We
I
held
don't understand what the conflict was, Sheriff. I'm sorry.
Sure.
Pick your bill, cut and lose.
What you're saying is that law enforcement officials, I believe, if I'm reading you correctly, can hold a person without charges while you decide, or while the law enforcement official decides what's going on.
Actually, no, it's not that ad hoc, and nor is it that subjective. It requires us to be able to hold somebody until we have the approval for release by the feds. And that's exactly what had happened.
But you never notified a detainer is only good for 48 hours. You're saying you needed approval from the feds. Couldn't you just turn that around and call ICE and say, hey, can we have your approval too to release them?
Really? Is that really how cavalier that we're supposed to operate? Just like on a whim or wink or nod, that we just call ICE and say, hey, we've got this guy? No, we follow the law, and the law requires us that we have to hold and then release somebody based on the time that they're required to be held. A detainer is not a legal instrument. That's already been established. Arguably, that may continue to be import for further discourse, but it was not. And the feds were well aware of this, because through the FBI, through the CII, and through the fingerprints, they're well aware of what his disposition was. It wasn't like they just transferred him and forgot about him. They have the same FBI record number, the CII number, and the fingerprint system that gave the complete chronology of what his status was. In any one period of time, ICE could have acted as they had the previous times for deportation.
So you're basically saying that you don't want the federal officials to ever call you if they have somebody who's being released to see to honor your warrant, because otherwise you might release them.
No, actually what I'm trying to say is that the law has changed. I'm a sworn peace officer, member that leads a law enforcement agency, and I'm required to follow the law, and that while our laws are changing, affirmed by federal court, that if there is any kind of an inherent conflict, then I think that that needs to be reconciled by the appropriate stakeholders.
So if they're going to call you, they need to get a warrant first, otherwise you might release them.
Not at all. They warrant or court order for judicial review, and we're not alone. There's over 300 cities that feel the same way. Unique not anymore to San Francisco, although maybe we were early in this. Why would so many other cities move in this direction? And why isn't that
If
also
they're gonna
part of the
call
debate?
you, you're saying, don't call us, because if you call us, we'll take custody, and if you don't get an order to keep us from releasing him, don't call us, because it's your fault for calling us in the first place.
No, what we would say is that even if a call, and it's not a call, by the way, it's a piece of paper. And by the way, on documentation, we'll provide, what are the 3 documents?
We have a log of the time that call came in, we have a copy of the actual warrant, and we have a copy of the routine letter that is returned by our central warrant bureau.
Do you have a copy of something indicating the confusion in terms of why you held them for an extra 2 weeks?
That's on their end. You'll have to get that because that requires us. We can't release somebody unless, of course, that we have the approval to release them.
BOP says they released them because his time was done. That's what BOP has told the Associated Press. Sanchez's federal prison term had come to an end. That's why he ended up in San Francisco.
And
so if you have some details on what the conflict is, I'm all ears, but I don't understand what the conflict was, Sheriff. So
well, they completely knew then when he was being released. They talked to ICE.
So they shouldn't have contacted you then at all. They should just have let him release it. Don't honor your bench warrant, because if you take him in on your bench warrant, it's without absent a court order, you get to free him.
But they did that 4 times previously.
Right. So that's what you want them to do in the future.
Well, I think it just raises a question. It's not whether I want them to do or not want to do. We're spotlighting an example, an exception that they didn't honor over the 20 years before.
This could every time they contact you on an outstanding bench warrant, absent a warrant that you say needs to be filed, releasing someone to you, if no matter what the offense is, no matter what the issue, absent a warrant order that they get before you pick this person up, you'll free them.
The important thing to walk away from is we require a warrant or a court order. If there's exceptions to that rule, then let's have a stipulated agreement what those exceptions are. But I don't think we can be subjective as to who we are calling ICE and who we are not, unless we have, I think, are enabled to do just that.
After this case, have you gone back and looked to see if you may have released other Sanchez's that we might be worried about?
Sheriff, you've got 5 more minutes for questions. Right. But state law does give you that
No,
discretion.
no, we do not, because we would not always know.
State law does give you that discretion. Are you saying that San Francisco law trumps state law? I mean, the charge by former U.S. Attorney Rusinello is that San Francisco operates like its own city country with its own laws and a heck of everybody else. Is that what happened here?
Yeah, I don't think Mr. Rusinello is correct on that at all, because the ordinance that was born has to then sync with state law, and that's approved by our own city attorney.
Did you ever have any contact with ICE at the time? Anyone to say, why are you honoring this warrant now? Why are you sending him to us now? Did anyone ever ask them why after deporting him 4 or 5 times?
No, we would love an answer to that, and that has been evaded.
On Tuesday morning,
to clarify, it wasn't ICE that called you up?
It was Bureau of Prisons.
Federal Bureau of Prisons,
right?
yeah.
Sheriff, on Tuesday morning.
And no, they have not responded.
The paperwork
Sheriff, on
they gave you
Tuesday morning on
indicated a nice warrant on it?
you said something to the effect of, we're trying to understand why ICE returned Sanchez to San Francisco on a 20-year-old marijuana possession charge. It doesn't appear from the chronology you gave that ICE had any role to play in that procedure. Did you not understand at that time, or why put that on ICE to create the transfer?
I think the term was feds. We meant to say feds, just the feds, Federal Bureau of Prisons. And they talk to each other.
But you said ICE.
We mean Federal Bureau of Prisons.
Did he come with any kind of order indicating that he should be turned over to U.S. probation? And why didn't you honor that order? Why not just drop him off at U.S. probation?
I'm not aware.
I'm not aware of that either.
So there was no signed order that says he's to report to U.S. probation?
Not that I'm aware of.
Yeah.
If you were to change the city law to satisfy this, would you change the law? And if so, how? Or are you happy with how things are?
Well, I think a tragedy of this dimension requires us to all step back and review the efficacy of the law itself. But I look to the legislators and the mayor to help speak to that. And as a former legislator, I think it requires, as you all have witnessed in the city before, for an issue that I think is as controversial and as high profile as this, a very intense discussion, which is why back in February and April to ICE leadership, that I said they should really participate in this discussion if that is their intention to then alter their former program, Secure Communities, or their evolving program, Secure Communities, that had been transferring and deporting undocumented people.
Would your own policy give you, under the policy we've seen, seems to give you discretion to determine whether you'll even honor one of the orders that you're saying they should have gotten? Do you have that kind of discretion under your policy, and would you exercise it?
That really depends on counsel for our attorneys, but again, the discretion is predicated on the fact that we're operating on the principle that the detainer is not a legal document. Even on top of the detainer, although I think ICE just changed the nomenclature of the detainer on July 1st, it clearly says voluntary. A voluntary action is right on the detainer request. If you look at their form, it says voluntary.
So basically, you'll never honor an ICE
While
detainer.
you checked with him.
I'm sorry?
After his charges were dismissed, you held him for an indefinite amount of time.
Well, as I answered before, on the Fed side, they couldn't tell if his time had been finished or not because of whatever other concurrent time that he had been serving.
I'm saying you described it as voluntary in one sense, but it seems a little more like a courtesy now than after the charges are dismissed.
But the courtesy had already been established when I met with and when the city had signaled by change of law and subsequent meetings with ICE leadership and a number of the sheriffs in the state of California that had reiterated that the laws are changing here. This is what we require from ICE. And if they don't follow through, which they have not followed through, then as this unfortunate incident is highlighting, that needs to be reconciled. But we still require that resolution about the detainer being unconstitutional.
So the point is, even if the city changes their ordinance to like how Senator Feinstein wants it, you still have your own policy suggesting that even if the city changes its ordinance, you can continue your own policy. True or not?
Well, thank you, Kate. Thank you. So, no, not quite. I mean, I think that I appreciate the lead in the baiting of it. If you know, I don't think that Mayor Lee or Donald Trump can waive the Constitution. I don't think that they can, or a senator. I think that no matter what the issue is, born out of the, I think the sadness and concern about how we all got here, the other issue will remain the same. No matter how ICE morphs into a different program from what they used to do for transference and deportations to this new one that I understand is being rolled out called Priority Enforcement Program, those details still have to be resolved on the municipal level. And I look to the Board of Supervisors and the mayor to resolve that. If they do, and they can, absolutely we'll adhere to that. Our policy will continue to reflect the spirit and letter of the law.
Sheriff, have you ever known the Bureau of Prisons to release someone on a bench warrant mid-sentence?
I don't know if it's mid-sentence, but I am not familiar if they had before. And I have to tell you, from an insider perspective, it is just odd that on a 20-year marijuana warrant for a city that rarely prosecutes for this charge, that they decided now after they deported him 4 times.
Well, that's the point you're making, though, Sheriff, of whether or not of the hold after the charges were dropped to figure out if his sentence was over.
Well, that's what we kept calling them. There was a lot of communication.
But why would you even assume that if he was released on the bench warrant, released for the bench warrant, that he still had federal time to serve?
Because our deputies were in contact. You have to look at the time. He had aliases, and so we wanted to make sure that we had the right person based on the shared database that local, state, and federal agencies have access to.
If there was an order to return him to U.S. probation upon his sentence, would you have honored it?
Oh, sure, absolutely. Yeah, but again, I mean, again, we would honor deportation. We would have to. But a warrant and court orders would help facilitate that deportation, as ICE firmly knows, because they've deported him so many times before.
Why did you say that city law
Sorry?
Why did you change your policy? Why did you issue multiple memorandums of what the policy
Yeah.
That's your last question, Sheriff.
Oh, thank you. And so somebody who hasn't asked a question yet, too. The law itself, when it was passed, due process for all, didn't at all explain to the line deputy and to the department how to handle the operation and procedure on a day-to-day level. And as we were trying to really interpret and assess the legalities with the city attorney of San Francisco, our policies also evolved too, so that we can come to a workable understanding of how our line staff should operate. And ultimately, our legal staff, so that they don't feel in an uncomfortable position or a position where they're being asked to make a decision when they are legally not legitimized to, we ask them to contact our attorneys. All right,
Sir, one
folks.
last question. Did you say that city laws trumps state law and federal law?
No, I never said that.
But you said that, you know, unless it's.
I think the word was mesh and sync. So that was the no, but they absolutely, if there is any conflict, then that needs to be resolved. But our local law, just like it's been shared with 50 other counties, 50 out of 58 counties, it's a very similar law. So then you're saying that 90% of California counties are out of sync within state or federal law.
That's it, Sheriff.
Okay, thank you, everybody. Thank you very much. Appreciate it.
I've got press releases and other documents out here for y'all to take. Please make sure you get them.
I'm glad I got to know you guys.
Is there anything else that, can I ask you a question? Is there anything else you should have?
No. Simple. I enjoy it. Why